Samuel Trapp coming to you live from the Lake Ozark Real Estate of the Art Studio. I thought I'd put one of them little blurbs in there that goes, hey, it's damn radio. Shut up and listen. Quit listening to music and listen to me instead. Apparently not, though. Sorry about that. Little bit of confusion this morning. So we're going to start with presidential wit and wisdom this morning from the Lake Ozark Real Estate of the Art Studio for Civic Outlaws here on Fridays, which Civic Outlaws Fridays. You want to become a civic warrior? Go out to civicoutlaws.com. Join us, because what we are is very much against government overreach. We are against the world where the bureaucrat controls your life. You all know my history. We'll go over it again one day just because I like doing it. And I'm right, but hasn't done me any good. I lost to the bureaucrat. So, but the fight continues. That doesn't mean you don't quit just because, if it's right, it's right whether you win or lose. Right, friends and neighbors? I'm going to give you a Millard Fillmore quote this morning regarding the law. Ready? The law is the only sure protection of the weak. Not positive of that. And the only efficient restraint upon the strong. I agree with that concept wholly. That is good stuff. But that was Millard Fillmore said that. And he said, let us remember. He also said, did Willard Fillmore. Willard, thinking Willard Scott, Millard Fillmore, Willard Fillmore, whatever the hell it is, but it's Millard Fillmore. Let us remember that revolutions do not always establish freedom. Remember that. Our own free institutions were not the offspring of our revolution. They existed before. It's an interesting take on reality, isn't it? Not necessarily against that. So all week I've been prepping this on my International Flavor Show, talking about what I plan to do on Friday. Had some lot of I don't know what ups and downs. A lot of research done this week on my end. A lot of writing. I already told you that when did I write that damn thing? Can't remember. Monday evening, Monday afternoon, I wrote an article about, might have been in the works over the weekend too, I think, where the article is entitled, When a Licensing Agency Becomes a Clandestine Police Department. And I want to share that with you. But during this week, I became aware of a bill that is on the House floor, directly impacting what I was going to share with you. So I'm hoping that I can get through both of these. So I think I'm going to jump right to it. And I apologize if it sounds like I'm reading, because I am today. But they're my words. I wrote them, okay? And, I would like to perhaps go back to, get some wisdom from YouTube somewhere. The Epstein deals and the old Billary element, the Bill and Hillary, are, she never met Epstein. She's never met him. Why in the world was his compatriot, his partner there at her daughter's wedding or wherever the hell they were, whatever these things were? I'm sure it's Bill's fault. Can't be Hillary. Jesus, she's clean and pure as the driven snow. At least that's what I've always heard. That he may have been soiled, but she is pure as the driven snow. Boy, I even have a hard time saying that. Sometimes things are so mistruthful that you can't even let the words out of your mouth. If you feel like calling in this morning, please do. 573-746-8020. But my intent is to share these articles, and it's a bit of reading. My words, my thoughts, with the help of a couple of researchers at Civic Outlaws, that we bounce things off each other's brains. We different perspectives are always highly useful, as I say in many, many things. The point of view of an Afghani versus a Pakistani, now that they're exchanging missile bombs towards each other, is probably not the same. It's going to rely a little bit on perspective. The hundreds of drones and missiles shared between Ukraine and Russia overnight are probably important to consider the perspective of where the point of view is coming from. So I want to talk to you about a licensing agency. And one of the things that I want to preface it with is that obviously if you're a regulator, your point of view is going to be different. If you're a bureaucrat, it's definitely going to be different. I say that people that work for the government should do their jobs, be regulators, not bureaucrats. Bureaucrats are those who increase their power. Bureaucracy is the enemy. You know, the long time, the growth of power to becoming fabulously wealthy just because you happen to serve, if you want to call it that, the people, I think is horse pucky. And I'll try not to swear, but I got a bad mouth. I served in the Army. You know, I've got my, and I'm going to apologize because last week, not only do I have a bad mouth, but I have I'm not very good sometimes with technology. And last week I jacked it up on the way out of here. And a wonderful woman and a very good show came in and had a couple of guests, and there I was ranting after pushing the wrong button, and I said some swear words, and I didn't have the speaker off because I was confused. And so I apologize for that. I will try to be a better citizen in the future, but, well, sometimes you just can't say things like you could with a swear word. You know, I hate to say that, you know, but it's true. One swear word, you know, certainly in Russian, one swear word will help you out. And it just gives you the connotation of exactly what you're looking for, you know, just by saying it. French do it too. Many languages have their swear words. But today we're going to start with an article that I wrote. I'm really concerned about government overreach. All of you know that, that listen to me regularly or on Civic Outlaws come Fridays. And this is the third increment of Civic Outlaws. We're still trying to get the website to align correctly. And a few of that is my setting part. And some of it is the settings that our esteemed website developers and technology folks have to help me get to, but perhaps it's because I can't explain exactly what I want. But once I do, Civic Outlaws will be fixed, and we're going to create a subdomain called podcast.civicoutlaws.com and blog.civicoutlaws.com. They're in the works, and I really apologize for the inconsistent or perhaps not inconsistent, because I believe we're pretty consistent, but with the perhaps disjointed nature of our website at present. But it's getting a hell of a lot better than than it was. And I'm not the best, or haven't been the best at describing exactly what I want, but we're getting there. You know, they're extracting the information from me as we go. So this is good stuff. So I'm going to start with when a licensing agency becomes a clandestine police department. Now, the world is changing, as we've outlined over the last two shows, as a result of the overturning of the Chevron doctrine by the Loper-Bright decision, and Missouri specifically implementing RSMO 536.140. And now, I believe there was a tiny bit of an end run, maybe unintentional, I don't know, attempted to be done in the legislature this week. And, you know, I jumped on it with my team, and we gave a reality check to that. And, you know, if that's what Missouri wants, which I'd be surprised if they do, fine, but let's do it openly. Let's talk about it in the open. Let's get it all out on the table and see what it is. So I'm going to start with what brought all of this about is the overreach of the alcohol, tobacco control people. Okay. Now they have been put into place to have, to do what? What do they fight? What do they regulate? Alcohol and tobacco, okay? Alcohol and tobacco, that's it. Chapter 311 is alcohol. Chapter 407 is tobacco. This is the limit of their realm. Their kingdom extends to those two subtopics, right? Those are the topics that they get to regulate. You know, we're regulators. This is what we do. This is what we love. We want to tell you what to do. And there's some sad truth to this, that you feel targeted when these guys come after you. This is not a cooperative thing. You know, I talk about that in respect to my own profession and have for years. This isn't a cooperative, hey, fix what you're doing and move on. Let's make sure that you're doing it correctly. No. It's what bureaucrats do. They come in and they try to destroy you instead. For some reason, they have to justify their existence by destroying others. I've never understood that approach. I just don't get it. And it makes no sense to me. You know, I'm a more power to you. You know, you want to have a talk show that competes with mine? Let's do it. You know, come on in. Heck, we'll talk together. And it'll be fun. And we'll learn from each other. You know, because I may not be right all the time. What? Did I just say that? Maybe so. Anyway, I'm right about this, and I'm right about the overreach of alcohol, tobacco control. And so I think that people need to understand that. And so article number 3 that I finished up Monday or Tuesday of this past week, I'm going to share with you even now. Okay, and then it'll be published out at our site. And what we do with these when we come up with them, and I finished another one yesterday morning, I think it was. I'm going to try to share that one with you too in the next hour here. And for both of these, the first one is called When a Licensing Agency Becomes a Clandestine Police Department. That's subtopic Article 3. Article number 4, which I finished up yesterday, is called HB, House Bill 2378. It's Quiet Legislative Creep. The upgrade of the ATC into a police force. That one's frightening. That one, holy crap. I read it and I was like, wait a minute. This is, anyway, we'll get to my paranoia about that in a little bit. But I'm going to share with you about this licensing agency becoming on its own, taking its power on its own, by itself, taking its authority and creating its own authority to be a police department. Here we go. I begin. In the first 2 articles in this series, we examine the structural architecture of Alcohol Tobacco Control Authority. Article 1 addressed the problem of regulatory overreach, how an administrative agency charged with licensing quietly expanded its interpretation of illegal activity through rulemaking and elastic application of statutory language. Article 2 then examined the mechanics of that expansion, how they did it, how criminal statutes, particularly within Chapter 573 and 572, by the way, chapters of Missouri revised statutes, were imported into Chapter 311 licensing enforcement through administrative interpretation rather than legislative amendment. We analyzed the circular logic that results when an agency declares conduct criminal by reference, then uses that declaration to render a premises non-compliant, and finally leverages that determination of non-compliance to threaten or revoke someone's license and livelihood, by the way. Those prior discussions focused on legal theory and structural boundaries. They asked whether ATC had stretched its delegated authority beyond what the General Assembly authorized. Here at Civic Outlaws, we believe they did. They examined the bootstrapping of criminal provisions into administrative regulation and the practical consequence of allowing a licensing body to function as prosecutor and adjudicator under a lower standard than criminal law requires. This third article turns from theory to documentation because while Article 1 and 2 examine the legal expansion of authority, the documents that are in our possession reveal something even more troubling. The Division of Alcohol Tobacco Control repeatedly referred to itself in official investigative reports as a police department. Not metaphorically, not casually, formally. For several years, official investigative reports generated by Missouri Division of Alcohol Tobacco Control bore the heading, Missouri Division of Alcohol Tobacco Control Police Department. That is not interpretation, not rhetoric. It's printed in bold at the top of official state documents. Multiple investigative reports across different years and different districts use that exact designation. No. How do you just take your own? No, I'm off the written script now. How do you take your own agency and just start calling it a police department? Okay, I'm Sam. I've decided that, you know what? I think I'm going to start a police department. From now on, I want you all to refer to me as the Samuel Trapp Police Department, and I'm going to start taking authority for that. It's the same damn thing. I'm going to morph into my own police department. I'm going to put on a SWAT outfit, and I'm going to, go buy me a black SUV and put some dark windows on it so nobody can see in there. And then, put a gun with a turret on the top of it. And I want you to, from now on, to refer to me, I identify as a police department. Not metaphorically, not casually, but formally, from now on, when you refer to me as the Samuel Trapp Police Department. For several years, back to the article, official investigative reports, when the language of these reports was brought to the division's attention through sunshine requests, which is where we got them all anyway. Now, when I went through these, and I haven't been able to find the exact one, I would swear that I saw one that was back all the way to 2019. My bet is, yes, it's there, and I've misplaced it because we've received some 5,000 pages from ATC. They quit responding. Now they won't even respond. Now they create obstacles to response, as we've discussed several times this week. But when we brought the language that, oh, by the way, why are you calling yourself a police department? What gives you that authority? The initial response was not an explanation of statutory authority. It was denial. Kristen Cole, Director of Finance and Compliance, responded in writing, ATC does not identify ourselves as such, either in correspondence or anywhere else. Quote, our recognized agency name is the Division of Alcohol and Tobacco Control, as authorized under RSMO Section 311-615. That categorical denial was followed later, when confronted with copies of the reports themselves, by the explanation that the clandestine use of police department was just a glitch. I forget what the official word was they called it. It wasn't a glitch. It was a, darn it, something. So, whatever it was not intentional. And I can't remember the word. A glitch that appeared on multiple reports over multiple years. A glitch that coincided with armed post-certified agents. Why are they armed? Why in the world are we arming these guys for license investigation? No wonder they act like policemen. If you want to be a policeman, fine, go be a policeman. But you're an alcohol control guy. All you do is verify somebody's license, and you got to frighten the hell out of a business owner because you want to come in there. And why aren't other licenses regulated at gunpoint? I don't get it. Makes no sense to me. It's not 1930 anymore, or 1925, or whenever Prohibition began. Anyway, when administrative licensing agencies repeatedly caption themselves as, or their official investigative reports as police department, that's not a typographical slip. It's an assertion of identity. And institutional identity requires statutory grounding. Chapter 311 of the Missouri Revised Statutes grants the supervisor of alcohol tobacco control authority to administer and enforce liquor law. 311 authorizes investigations of violations of not all law, just Chapter 311 and related regulations. It does not create a municipal-style police department within the ATC. It doesn't. They're doing anything they can to avoid answering us. They sent us one bill of $390,000 and said it would take 44 years to answer our questions. Nonsense. And then most recently, we sent one and they said it'll take 53 weeks and $8,000 to respond. Nonsense as well. It's just a form. And they give an annual report every year that allegedly gives a lot of the same information. Why would it take, if you give the annual report including most of the same information, and all we want is a copy of the form? And why would you claim it's going to take you a year to figure that out? I'll bet you $100 that if a fearless state rep or senator called and said, hey, I need these documents, you'd figure out a way to get them there. Guy named Dwayne in the in the discussion chain of the 5,000 pages we got, some investigator was not investigator, one of the administrative bosses in there was well, here's what we got from Dwayne. I received this from Dwayne the other day. They had no problem providing us with 170 pages of investigations they had done by date and location that they clearly printed from a database. But now when we ask for that same information in a different format, they can't provide it. Takes them a year, takes them 44 years. These guys are playing with us, and that's that. And I don't believe it. Convince me I'm wrong. Pick up the phone, call me at 573-746-8020, and tell me I'm wrong and why. It's nonsense. Let's get Dwayne to go in and see if he can come up with it, because he came up with the other documents pretty quick. Anyway, administrative agencies are creatures of statute. They possess not only the authority the legislature... there I went. They possess only the authority the legislator grants. They do not possess inherent police power. If ATC wants to operate as a police department, the statutory basis must be clear. If it is not, then the repeat use of that designation is a serious structural problem. The police reports that they provide reveal an operational posture as a police force as well. In one such report, an agent entered a liquor license establishment. Get this. Here's the quote. In a covert fashion, with no ATC identification on my person. Another agent remained outside as, quote, my safety officer in the event of an emergency situation. What emergency was the agent contemplating while verifying compliance with a liquor license? Seriously. Once inside, the agent conducted surveillance, documented alleged conduct, purchased alcohol, carried it outside, and later logged the Coors Light beer sample in the District 5 office as evidence. This isn't licensing regulation. This is some guy out there playing SWAT, dude. All he wishes is that ATC guys got to wear SWAT machines. This is nuts. And so he's logging a bottle of beer in as evidence. There's evidence that they sell beer in a bar. Well, thanks. We didn't know that. And why are we being confrontational and investigating clandestinely, undercover, leaving your covert ID outside? What, are you afraid somebody will know you're a licensed guy? What are you doing? And if you want to be a policeman, quit being an ATC guy and go become a cop. You want to be, you know, go join the sheriff's department. And then when you have the right constitutional search and seizure under sorry, these damn TVs throw me off all the time. Under the Fourth Amendment, well, the search and seizure, then you can come back. But if you can just going to go in as an investigator, it's a totally different standard. And I'm so against this, I can barely stand it. And these guys get to go in and, well, I'm just doing my job. I'm going to say, you're not a policeman. You're a licensing agent. Period. Just because you have to be post-certified doesn't mean you're out there trying to arrest people. You can arrest them for violations, but by God, they better be one of the violations in the statute, you know, not something else. Anyway, once inside, the agent conducted surveillance, documented, and logged his Coors Light beer. His narrative described conduct in detail and cited regulatory and criminal provisions. By the way, he doesn't get to log criminal. He can't arrest you for them. Why is he doing it? Well, is anybody ever going to get charged off of these? One of the other things that I thought would be interesting to do is find out how many licensing reports under Chapter 311 or Chapter 407 were used to arrest people. There was something come up a while ago about one of these machine, you know, they have these gaming machines, and there was some kind of arrest coming in there. I'd really like to know about that. Is that just licensing leverage? I heard they were actually charged with something. I want to go through all of that too. I thought I've done a little bit of preliminaries, but I haven't gone far enough to speak super intelligent. But it appears to be exactly the same thing, that you go in and you allege violations of other law. which you don't have the authority to do. So anyway, the language in these reports is not that of a licensing regulator regarding a clerical compliance check. It's the language of a law enforcement officer. In another report, the agent recounted receiving an anonymous complaint that lap dances were being provided. The agent responded with an unannounced routine inspection. So this is how he gets in the door. So if somebody had nude lap dances, you got to go get a warrant somewhere if you're breaking the law, but not if you're just executing on an administrative license, right? That guy can come in and say he's a state agent. And then if he sees somebody given a nude lap dance, he can arrest them, right? Examined posted licenses, inspected areas. The report concluded that no further action would be taken. But the structure is unmistakable. Complaint intake, investigation, surveillance, documentation. Constitutional implications are not theoretical. They're concrete. The Fourth Amendment to the United States Constitution protects against unreasonable search and seizure. Supreme Court has repeatedly held that administrative inspections of private commercial premises, even in closely regulated industries, are subject to constitutional constraints. In Camara versus Municipal Court, 1967, the citing is 387 U.S. 523, the court rejected the idea that administrative inspections are exempt from Fourth Amendment scrutiny. And in that case, they were trying to regulate, was it fire protection? That they were saying that the house may have been a fire hazard, if I recall. Something administrative. Something saying that they didn't comply with the local structure. And the guy lived there. And it was his home. And they wanted to come into his house, and they said, just because you want to regulate something that goes on in your house doesn't mean you get a warrantless search and claim it's because of an administrative checkup. We're checking to see whether, I don't know, you are code compliant in your house. You can't just come in. That's settled law. And the question came up. It's like, yeah, but we're not going in there to Fourth Amendment search against this guy. We're going in there to regulate. Well, the Supreme Court disagreed and said, well, you better get a warrant if you're going in there to check enforcement that is there. And then in a case called C versus the City of Seattle, the citing reference for that, 387 U.S. 541, 1967, same year, the court extended that principle to commercial premises. And I forget what they were regulating there, but it was something similar. They went into a guy's business establishment, checking a criminal deal, and they're trying to mix the two together. Supreme Court says no. Well, I say no. It's BS. Fourth Amendment says no. That's an unreasonable search and seizure. You can't do it. You need a warrant unless you're going in just to regulate a license for simple purposes, right? So the court recognized a limited exception for so-called closely regulated industries, permitted a warrantless inspection under carefully defined conditions, something that protects your Fourth Amendment rights, some procedure that also protects, right? And in a case called New York versus Berger, the court held that such inspections are permissible only where there's a substantial government interest, the inspection scheme is necessary to further that interest, and the regulatory program provides a constitutionally adequate substitute for a warrant by limiting officer discretion and providing notice of the inspection framework. But Berger does not authorize covert criminal investigations by ATC guys masquerading as an administrative inspection while leaving your ID outside. And a backup dude outside. It's friggin' nuts. Now, in the Berger case, what Berger was that was an interesting case, and I can see this. I don't necessarily agree with it, but I get it, and I get where they're going. So in Berger owned he owned a junkyard. He owned a junkyard, chop shop, basically. And you go in, you drop off these cars. And so the police had the right under New York law to go into junkyards and verify that the vehicles you have there are properly titled. Okay. And now, if you're going to catch people who run a chop shop, what are you going to have to do? You're going to have to go. And so if you're checking their license, if you're going in for a criminal reason, fine. But if you're going to go in under a scheme that says, well, once a month, once every 3 months, periodically announced, we're going to come in and check your log of titled vehicles in your junkyard or any of we're going to make sure you're not running a chop shop. That's a legitimate government interest, I say. And so did the Supreme Court. They said, well, then if you're going to run this chop shop, well, the chop shop, you better be careful to document it properly. All the cars you buy better be licensed properly. And so they had the authority from time to time, and what they did was they replaced the element of the inspection. They replaced the Fourth Amendment with a procedure that limited the discretion of the officer. The officer couldn't just come in and wander around. They had to come in and check certain things. Check let's say you get to the front, but you can't necessarily go in the back unless you have some kind of a procedure identified to say, wait a minute, we've identified this. But if you have a complaint from somebody else that says, man, they stole my car, chopped it up, and I saw it through the chain link fence in the back, that is a different investigation altogether. You can't go in and use this procedure of the state of New York to go and inspect whether or not in the back your friend's vehicle is chopped up. That is not an inspection. That requires a warrant. All you can do is go in and verify whatever the procedure that is in place to protect. And if there's a question on that, the courts will analyze whether or not the procedure was sufficient to protect someone's Fourth Amendment rights. Okay? In a later case, Marshall v. Barlow's Incorporated, the court made clear that administrative search regimes cannot be used as a pretext to avoid a warrant, like the officer coming in with a police report, undercover, leaving his ID as an alcohol tobacco agent outside and having a backup guy out there coming in to check out whether or not you're breaking the law. Nonsense. If you think somebody is breaking the law, go get a warrant, come in and investigate them. Do that. But you don't have that authority as a licensee. As a investigator, as an agent. You don't have that, okay? And in the city of Los Angeles versus Patel, this one had to do with hotels. And I like this one, too. They had to certify several things as a hotel owner. Some people aren't living there permanently. They're not there more than whatever the amount was, 30 days, 30 days without leaving. They can't be there longer than 30 days. So the court, this was in 2015, the court reaffirmed that even in closely regulated businesses like hotels, inspection schemes have to allow for pre-compliance review, and don't grant unfettered discretion, okay? Discretion's a big deal when you're a police officer. Discretion is what protects you, that grants you immunity, which we'll get into in the other article, right? When an agent enters in a covert fashion, conducts surveillance, collects evidence, and stores bottles of beer as evidence to document alleged criminal conduct, the line between administrative inspection and criminal investigation is gone. If the true purpose is criminal enforcement, the Fourth Amendment demands more than regulatory gloss. More importantly, under what authority are they acting as police officers? I say none. They don't have it. They can only take simple view of their regulation in 311 and 407, their regulation. This issue deepens when criminal statutes are bootstrapped, like ATC does, through administrative licensing authority. RSMO Chapter 572 governs gambling machines and criminal offenses related to thereto, and Chapter 573 governs criminal offenses related to adult businesses. People selling, adult toys and stuff. And it defines, child porn and stuff like that. And Chapter 573 governs that statute. 572 governs gaming machines. Criminal statutes have criminal procedures, require a criminal charging document, proof beyond a reasonable doubt, jury trials, etc. You don't get that for your liquor license. So you can't liquor license agent, you can't charge them with a crime. You don't even have that authority to charge them with a crime. Instead, ATC declares alleged violations, as I talked about with their lawyer in the prior article number 2. Their lawyer in front of Judge Beadham, Jesus, that was ages ago. In front of Judge Stumpy, it was Beadham's courtroom ages ago. But Judge Stumpy up in Cole County, under administrative regulations, are the grounds for denial of a license. All you got to do is regulate the license, but you're holding it over their heads. And you know that you got this gun on your hip, which is nonsense, and the distinction between criminal adjudication and administrative discretion is gone. ATC's reliance on criminal statutes does not constitute an isolated interpretive maneuver. It's part of a broad pattern in which criminal statutes are absorbed into the licensing framework and reclassified as administrative noncompliance. ATC has imported its treatment of Missouri's gambling statute under 572, a body of criminal law that, like 573, contains no express delegation of enforcement authority to Division of Alcohol Tobacco. They can't arrest under those except they can't arrest under those 2 statutes. They can only arrest under 311. And they can't bootstrap the regulations of other statutes into there. So I call that administrative creep. Administrative mission creep appears in the way ATC's enforcement forms and procedures regulate prohibited gaming activities on a licensed premises, specifically gambling machines and promotional games of chance that have no nexus to Missouri's liquor license framework. Under Chapter 572 of the Missouri Revised Statutes, gambling is defined and penalized as a criminal offense. But these guys are using it as a club to beat you and take your license away. So you can't remove the licensing, remove a gaming machine. You don't even get charged with a crime of having a gaming machine. It's nonsense. And the same thing goes with 572. So 572.010 provides definitions such as gambling and gambling device, while 572.020 makes the offense of gambling a misdemeanor, and 572.070 makes possession of a gambling device a misdemeanor when knowingly placed or used in the state. Chapter 572 provisions are part of Missouri Criminal Code. They establish criminal penalties that apply to illegal gaming activity, and his enforcement rests with criminal law authority and prosecuting attorneys. Yet forms, like I told you about yesterday and day before, like Missouri Form 812-0569, ATC's investigative reporting form that is used in licensing law, and they can't even tell me the history of the damn form, by the way, include paragraph 16 that allows agents to check off gambling and promotional games of chance as an alleged violation on a licensing-related compliance review, even though the statutory authority for ATC is under 311 and 407, extends only to investigative violations and regulations promulgated under those chapters. It contains no express grant of authority to regulate non-liquor criminal statutes like gambling. There is no statutory language in Chapter 311 authorizing ATC to investigate or enforce Chapter 572 gaming, nor does it delegate any enforcement authority at all to ATC. What ATC's form effectively does is import criminal gambling prohibition into an administrative licensing matrix, allowing agents to treat alleged gaming device violation as licensing noncompliance, even though such allegations, if valid, are criminal in nature. But they don't have to prove a crime. They just have to allege it, decide that you've done it, and that's that, and they take your license. Nonsense. 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 They don't have the ability to do that. There is no statutory basis in 311 or its rules that delegate to ATC the power to enforce Chapter 572 gaming offenses. Nor is there evidence that the General Assembly intended to burden the division with enforcement of general anti-gambling law. ATC's inclusion of gambling violations in its investigative form demonstrates the same pattern of interpretive elasticity that appears with Chapter 573, where criminal conduct is translated into administrative noncompliance. Not even against the same person, often. This isn't merely an agency checking multiple boxes. It's an administrative expansion, conflating criminal statute with regulatory compliance. Missouri's criminal gambling laws are, by design, enforced through the criminal justice system, not an arm of the Department of Public Safety charged with liquor licensing. When ATC agents list gambling and promotional games of chance as a licensing violation that isn't neutral oversight, it's regulatory overreach using a criminal statute. ATC enforcers are very well aware of this expansion of their regulatory approach into criminal enforcement. Aside from operating as a police department, communications circling by acting state supervisor Templeton states that operation of a business in a manner that allegedly violates a criminal code is illegal activity under 11 CSR 2.140 and is grounds for the denial of a liquor license. Her language is explicit. Alleged criminal conduct is imported into the licensing framework as an independent administrative violation. This isn't regulation. It's structural consolidation of power. Now, I want to deviate here for just a second and remind you that the reason for this is because of Loper Bright overturning Chevron. She doesn't get to do that anymore. And they don't get to import, and they don't get to interpret. The court interprets, not her. And anything previously imported is now reviewed under Missouri law, 536.140, de novo, and must lean toward the review of overreach and look out for individual liberties. You have to err on the side of the citizen, of the person, calling forth that right. Templeton's March 16, 2022 email circulated among other senior ATC officials that forwarded an article called Chapter 573. She wrote that a challenge to the 573 statute had lost. Somebody years ago had filed against it. They didn't even know about it. But that certainly makes me feel better knowing the statute survived court scrutiny. In the same chain, staff discussed how we plan to handle these types of businesses. Her correspondence is not passive regulatory review. It is planning. She remarked that the division is blessed with autonomy. That phrase is not incidental. Autonomy in the administrative context means discretion. If you can get to the discretionary field, anything you do will be justified and immunities will not apply to you. That's a little sidebar. But if you have discretion, you have immunity. If you get to choose on the scene, you got immunity. And on federal side, official immunity on the state side. Nonsense. So these type of interpretations mean the ability to interpret yourself, to enforce, to prioritize. But autonomy is not sovereignty. It's a meaning not granted by a legislature. It does not permit an agency to expand its jurisdiction beyond what the statutory framework that created it granted. In the same series of communication, Assistant AG advised that a particular statutory provision, previously dormant in practice, could be leveraged in conjunction with ATC's regulatory authority. This tone is not uncertain. It's decisive. The message is clear. If criminal statute has survived constitutional scrutiny, then the division's licensing enforcement posture can be increased. What remains unclear is where the statutory authority regarding that posture originated. The discussion does not read as a narrow legal opinion about a statutory construction. It reads as an operational roadmap. If the licensee operates in a manner that could implicate a criminal statute, sole interpretation of the agent, by the way, then that conduct is categorized as illegal activity, again, solely by the agent, for the purpose of saying that they're engaged in illegal activity. If the licensee disputes that categorization, the division will proceed with denial or revocation of a license themselves. Only in the licensing stand, not a criminal charge. And so basically, they have to prove he's guilty, or they don't have to prove it. All they got to do is allege it because the standard of proof is different. That's the problem. If the business attempts to challenge the interpretation, the division can rely on the criminal statute survival in prior litigation as leverage to beat him up with and say, well, you're going to lose. And they usually do. They get him to admit things they'd never admit to because they just say, well, sorry. Well, otherwise you're either going to have no license or you were going to limit your license. How about that? So whatever punishments they put in, they strong arm you into taking because it's that or wait a year and a half while it works its way through the courts without a license, by the way. So you can, either kiss their rear end and take what they give you, but you can't fight it because, the structure is unmistakable. Identify statute, confirm that it withstands challenge, integrate it into administrative enforcement through some rule interpretation that you're not authorized to do anymore under the overturning of Chevron in 536.140, and deploy it strategically against a defined category of businesses. Templeton's communication chain reflects conditional planning. If the business does this, we respond with that. Yeah, and that's everywhere in this. If they resist, we escalate. They've been pretty clear about that. If they comply, we maintain leverage. That isn't a neutral administration. That's strategic enforcement. There is, through criminal code, by the way, there is no provision in Chapter 311 granting ATC independent authority to prosecute violations of 572 or 573 of the Missouri Criminal Code. Enforcement authority for criminal acts in those two statutes resides with the prosecuting attorney in the criminal court. That's true. But the internal correspondence reveals a conscious decision by this agency to use the existence of a criminal law that they can use in their favor as a mechanism to classify conduct as illegal activity within the administrative code, thereby converting alleged criminal behavior into licensing noncompliance without a criminal conviction. That's the point. Right there. You get to use a criminal code, call somebody a criminal, take their license away because they're a criminal, but you don't have to prove they're a criminal. That's the same thing that I argue they did to me about my bar license. They did the exact same thing. It's the same thing. And I'm telling you, people need to get this because those who agree with this type of behavior do not understand the Constitution. So that maneuver is not accidental. It is deliberate alignment. It is a tandem movement between administrative interpretation and criminal statutes. If you can call somebody a criminal and take their license away without ever proving they're a criminal, that's just wrong. It's just wrong. And that's what ATC is doing. It's the tandem movement between administrative interpretation and criminal statute without a formal transfer of criminal enforcement authority to anyone. The assistant AG provides the interpretive support. The division supplies the regulatory muscle. The result is a consolidated enforcement apparatus capable of applying criminal standards through administrative consequence. The implications of such regulatory overreach are profound. When an agency describes itself as blessed with autonomy and simultaneously outlines how to integrate criminal statutes into their own administrative licensing enforcement strategy, it signals a posture of expansive authority. Autonomy is elastic. Discretion is leverage. Leverage, when combined with the threat of a license revocation, is control. It's power. This is not conjecture. The language in the communication reflects confidence in the division's ability to handle these type of businesses. Whoever said that a licensee should be handled? Whatever happened to everybody working within a regulatory structure that isn't targeting people for destruction or destroying their business or taking their livelihood and holding it over their head so that they got to lick your rear end? That's, of course, not in the article, but I'm against this completely. Bureaucratic overreach is what this is. So they're going to handle these businesses. The phrase, how we plan to handle such businesses, carries a prosecutorial overtone. This isn't regulation of a license. It's a prosecutor. She thinks she's a prosecutor. It implies classification, targeting, and response. It does not suggest case-by-case, neutral application of statutory text. I want the legislature to do something about this. Administrative agencies are not authorized to bootstrap criminal enforcement through creativity. They're just not. ATC may enforce their statutes in their own jurisdiction. They can even promulgate rules consistent with legislative delegation of authority, but they cannot adopt criminal provisions as a strategic tool absent any clear statutory authorization. The fact that this strategic integration was discussed openly within the division in their emails underscores the evolution as a conscious thing. It was not a misunderstanding of a police report heading. It's not a typographical error. It's a structural shift in posture. For years, an alignment of administrative discretion with criminal statutes in a manner functionally expanding enforcement reach without any legislative amendment. Repeated police department designations on investigative reports and strategic correspondence paint a consistent picture. The ATC did not merely enforce liquor law, it developed and articulated a plan to use criminal statutes in tandem with administrative rules to exert control over a category of licensee. Autonomy in that context, however blessed, ceases to be a neutral administrative virtue. It is instead an instrument of expansion of the police state, of bureaucracy, says I. Regulatory agencies enforce administrative statutes. They do not handle certain categories of business. When internal email chains outline how the division will proceed against certain businesses after celebrating a statute, a prosecutorial posture is revealed. This is not a neutral oversight of a license holder and certainly not a passive compliance check. It reflects a criminal prosecution strategy. Self-identifying as a alcohol and tobacco control police department seems to be in keeping with that strategy. So now let's return to ATC's denial of that concept. When confronted through sunshine requests with the repeated ATC use of investigative reports labeled police department, they initially responded that ATC had never referred to itself as a police department. They changed that response after being provided with copies of the reports. Then they took on it was a system error glitch. The sequence of events, denial followed by minimization, is not a clerical footnote. It's a credibility issue. After all, the glitch occurred repeatedly over a course of multiple years and multiple jurisdictions. If such designations are a glitch, why are ATC agents post-certified? Why is that mandated? I would say, why are they armed? Under what statutory amendment? What is the legislative record? Who authorized the issuance of firearms? For what defined purpose? Are these agents exercising general arrest powers? Are they empowered beyond the enforcement of Chapter 311? To be sure, supervisor of ATC may select, I believe it's under Chapter 630, or Subchapter 630, subparagraph 630 of Chapter 311. And supervisor of ATC can select and designate certain ATC agents to be post-certified, but they all are. Certain agents may be, but they all are. They got all. I'm surprised they don't have SWAT gear, but that does not automatically transform every employee of the division into a peace officer. That designation is discretionary, not universal. Nothing in the statute requires that all investigative personnel be commissioned. Nor does post-certification itself mandate that a peace officer carry a firearm. Post-licensing establishes training and qualification standards under Chapter 590, Revised Statutes of Missouri. The decision to arm an officer is an operational and policy determination made inside the agency. The statutory framework raises legitimate oversight questions. least in my mind. How many ATC personnel have been designated as peace officers? I believe it's all of them. Under what internal criteria and for what defined enforcement scope? If designation and arming are discretionary, what policy governs that decision, and how is it limited to the subject matter jurisdiction expressly granted in 311? My question, my question personally is more basic. Why is a weapon necessary to manage a liquor license? Is it just the regulation of a certain type of liquor license? Does a licensing agent for any other type of license need a weapon? Perhaps barbers are suspect. Should the Missouri Board of Cosmetology and Barber Examiners be post-certified and issued weapons? Let's start, look at, what if in the back, like in all the old movies, that they, the barber shop is the place for the criminals to meet, in the back, right? In big cities, obviously. We should arm the cosmetology board. And when you go inspect barbers, you better be strapping. Anyway, if the answer is that post-certification for ATC agents is necessary for officer safety in a volatile environment, why is a bar any more volatile than anywhere else? I've been in a lot of bars. I got punched once, years and years and years ago in Colorado. Colorado's not Missouri. There aren't bar fights in Missouri, are there? And I didn't even do anything. I got saved by the guy's girlfriend. That was actually pretty funny. Oh, leave him alone. Anyway, I digress. The answer is post-certification for ATC is necessary. If that's the answer, that may justify limited peace officer authority, several of them maybe, narrowly confined to liquor law. It doesn't justify labeling the Division of Police Department for years and arming everyone. It does not justify covert operations that resemble some kind of vice enforcement. It does not justify importing a criminal statute into an administrative proceeding as leverage. Consider the structural danger. A liquor license is issued to a person or entity. It describes approved premises. It isn't granted to the walls themselves when the ATC declares that the premises are not compliant because an alleged criminal conduct occurred therein. It transforms the accusation into a regulatory weapon. The same agency that investigates makes the determination that the license is in jeopardy. Doesn't that bother anybody else? The same alleged conduct that could be prosecuted criminally is instead adjudicated administratively under a lower standard of proof. That is consolidation of investigative and punitive power, and the inspector wields a gun to bring that point home to the license holder. The U.S. Supreme Court cautions against such blurring of authority. In Michigan v. Taylor, 1978, Michigan v. Clifford, 1984, the court emphasized that administrative entry cannot be a subterfuge for a criminal investigation. You hear that, ATC? Pay attention to that. That's important. When the purpose shifts from regulatory compliance to evidence gathering for enforcement, constitutional safeguards intensify. And the Fourth Amendment kick in. If ATC is conducting an undercover operation, logging evidence and coordinating prosecutorial strategy, it should operate within the constitutional boundaries that govern law enforcement. It cannot cloak criminal-style investigation in administrative clothing to avoid scrutiny. In conclusion, I wonder whether the Missouri legislature ever intended the Division of Alcohol and Tobacco Control to function as a police department. If so, where's the statutory provision to that effect? If not, why have official documents and activities broadcast otherwise for years? Constitutional protections do not evaporate because a business holds a liquor license. Administrative convenience does not override the Fourth Amendment. Denial, followed by a glitch, is not a sufficient explanation. Either ATC is a police department with clearly defined legislative authority and constitutional constraint, or it's an administrative licensing body confined to the powers granted in Chapter 311. It cannot be both. That's article number 1. And clearly, I don't read fast enough, or I ad-lib far too much. And I didn't. That's just a long article. Now, what I found out after this, and we're not going to get to it today, But what I found out, this was frightening. So we've been sending this out to any legislator that'll listen and go, hey, somebody listen to this at Civic Outlaws. I'm not wrong. I invite people, come on this show, tell me I'm wrong and tell me why. You want to come in and argue with me or convince me. I like a good argument. That's what I do. It's what I live for. And so, in fact, I would welcome the chance to have somebody convince me that I'm wrong. And guess what? If I'm wrong, I'll admit it. And I will say, oh, well, I get it. Fine. So here's what happened. The other day, discovered quite surprisingly, I was surprised. Guess what? So the hearing on all these matters was December the 3rd of last year. There's a hearing in front of Judge Stumpy in Cole County. He's analyzing a couple of actions in his courtroom, and we say that, not we, I'm not even part of it. I'm just helping do a little bit of the research behind it, is Travis Noble's the one making the arguments, and this is good stuff. And I'm assisting in that regard. And so some of the research stuff, because I like this area, and I'm a fairly good research assistant. so that's what I'm doing. And plus I'm a founding member of Civic Outlaws. And so I think this is important stuff, that if people don't understand why the government shouldn't be sitting in your lobby every day, the words, we're with the government and we're here to help, are bullshit. Pardon my French. They just are. They're not here to help you. Certainly ATC is not here to help you with their SWAT gear or tactical gear and their backup outside so they can check whether you're, selling liquor to a minor. Nonsense. All of this is crazy. So I came, something else that got me going the last 2 days, discovered this House Bill 2378. And now what they were trying to do with this, and this is, so I'm a little, let's call it skeptical. And I can't share this article with you till next week. I don't have time to share it to you today. It'll take too long. And it's a long article. But I've shared it with a number of state reps, some on the committee, including the guy who sponsored House Bill 2378. And what 2378 was trying to do was exactly in ATC. Get this. To take, and the short story is this. Under this new House bill, one line of text under the House bill, and I don't have a copy of it in front of me, but the basics of it were this. They want to grant, this particular legislator anyway, wanted to propose that an ATC agent had the power to arrest in emergency or exigent circumstances. What does that do? What does it do? It takes discretion away from the court, away from Judge Stumpy, and gives it to the officer on the ground, or the agent on the ground. He's not even an officer. I mean, he's qualified. He's previously was an officer, worked for a police department most likely, and then transferred into ATC so he could still pretend to be a policeman without being a policeman. He's a regulator. That's it. He regulates a license. But if you can give him discretion, guess what happens? This is no longer a legal argument. It's an argument of what does the officer get to say on the ground, because the officer on the ground is given the discretion. And what does that do? It does two things. One, you can never sue the guy for overreach because he has the discretion. The discretion is his to make. And so the only thing would be and they get immunity for this, by the way. On the federal level, it's called qualified immunity. And on the state of Missouri level, it's called official immunity, that as long as you're acting in your capacity and you're given, and you're acting as a reasonable officer in a similar situation would do, but they never question that. If you say it's an emergency and you feel that it's an emergency as a police officer, that's why so many of them get away with killing people. You kidding me? This is frightening to me. They already are arming these people and they don't need to be. What if you come into a business, a liquor license holder, and that liquor license holder, you already have a predisposition to not like the guy, and you want to screw with him because you're an officer of the ATC and you want to take his license or you want to do more, and You decide you don't like him, but you're strapping, and he pisses you off. Guess what? If you feel threatened or in an emergency, you can do it, and that discretion is yours. He tries to. Now it is no longer an administrative thing, is it? And what if he escalates it? Fourth Amendment out the window. Doesn't matter. It's only on his discretion, right there on the site. Nonsense. Shouldn't be that way. So that is why I have shared with you this article. Next week, I will share with you this House Bill 2378, the quiet legislative creep. If you want an early copy, send me an email to samuelt@civicoutlaws.com, and I will happily share a copy of it with you. It may be, I think I'm going to put it out on my LinkedIn page early as well. The clandestine agency police department, I'm going to make sure is properly logged to, and I have shared that with you. That is all I have for you today, and I appreciate you listening to Civic Outlaws. I'm glad you're here. I encourage you to go out to civicoutlaws.com and support our activities. We are doing some very good things in trying to keep the bureaucratic class, that creates their own regulatory basis to regulate you. We're trying to keep them in line to the extent possible, and I encourage you to do that along with us to participate. civicoutlaws.com. You can send me an email, samuelt@civicoutlaws.com. If you have a particular area you would like to go to. This is about alcohol, tobacco, and their overreach. We're also have things going on with flock cameras and the danger of those and how similar things have happened in there, and a couple other actions that you can find on our website. We encourage you to do so and to support our efforts of our 501c3 with the education of the public. If you'd like to get on and talk with me about a particular irritant of bureaucracy, I'd be happy to do so. I appreciate you being here. Thank you very much, and have a very good Mid-Missouri day.